I've also left some business cards here in both my general counsel card and my special counsel card. If any of you want to take one of those on the way out, certainly you're welcome to do so, particularly if any of these sorts of issues involving ethics or conflicts confront you on any day-to-day basis in the future, or any other general legal question you may want to refer to me in my areas of practice. As you will see with the handout that I have circularised, the topic today is ethics, what would you do? And the way that I want to do this is to go through a series of questions. There are about 13 questions there. And as I say, ideally if we had a couple of hours to go through them, we'd have more ability to talk through variable scenarios of the questions and or more discursive analysis of the relevant principles of law, and in particular the professional conduct rules that help you answer them. But because of the time factor, if I seem to be going a bit quickly through them, it's because I'm conscious of the time that we've got to get through the exercises. At the back of that handout, aside from the questions, the ethical questions for consideration, there is a copy of the legal professional conduct rules, the New South Wales authorised version. These are now the Australian Solicitors Conduct Rules. Even though we don't have uniform legislation in Australia which regulates the legal profession, you may be aware that the uniform law as such only exists in New South Wales and Victoria, and it's really not so uniform. It's about 90% uniform. But Queensland has a different Legal Profession Act, and so does South Australia, has a different Legal Profession Act again. And in fact, the South Australian one, ironically, is the one that New South Wales and Victoria both jettisoned after 10 years using it. And Adelaide then brought it in at the same time. That's because they debated for many years about whether they would bring it in or not. And having gone through that tortuous exercise of deciding to bring it in, ultimately, and the length of time it took to get agreement to bring it in, it was too much of a rush then to move forward to the next change. And being a smaller state, I think they saw Queensland was pausing. And I always say, in retrospect, Queensland actually did the right thing by not adopting the uniform law. That's my own personal view. Rather pause to see how it plans out and then look at it for the benefit of a couple of years' practice. But anyway, this is the law for New South Wales. These rules largely restate a lot of common law principles and ethical principles. A lot of them also restate what were the professional conduct rules in previous guises under the Legal Profession Act of New South Wales. There are some additional ones, quite important additional ones that have been incorporated into the uniform law rules. Well, that's the Australian rules now. And I'll refer to those as we go through. Just before we begin looking at the exercises, if you look at the uniform rules, in particular number 3 and 4 and 5, those three really are the overarching three rules that dictate or give impetus to how the other rules work. The first one, which has always generally been accepted as the basic premise of professional conduct, is the ultimate duty of a solicitor or practitioner is the duty to the court for the proper administration of justice. There was a lot of debate about that before this had been enacted as it is, because in various arguments it was always said your duty to the client is the most important principle at work. That debate is about analogous to the debate that occurred at the time where in corporate law the general accepted principle had always been the most important duty of directors was the duty to shareholders to make profit, and then of course you see the evolution of the legal principle involving creditor interest and the duty of the community at whole taking root, so that the actual duty is the duty to the company as a whole overtook that duty of the shareholders thing. And this is a similar type of evolutionary development which is now clearly stated in the rules, that whilst traditionally you've always regarded duty to the client as paramount, coexisting with it is a duty to the court. And after all, as practitioners, we're officers of the court. Every time we get admitted, we go on a solicitor's roll of some state under the auspices of the Supreme Court of that state that admits us, and that's where you get the connection that we have a duty to the court as an officer of the court to ensure and assist the court in the proper administration of justice. And linked to that is the notion of public confidence in the legal system. And where public confidence falls down in the legal system, you will get public outcry. The most recent best example of that is in that case in Queensland, the criminal case involving, the murder by the husband of the socialite wife, where, the Court of Appeal basically said, oh, well, he should be let free, and there was absolute outcry and pickets and meetings in the streets, and ultimately the High Court overturned that decision on legal grounds, which were quite sound, but that ultimately showed the system worked to restore public confidence back into the system. So it is linked in that respect. So the paramount duty to the court and administration of justice, and as a solicitor there, accepted principles in Rule 4, you act in the best interests of a client, you be honest and courteous in your dealings in the course of legal practice, you deliver legal services competently, diligently and as promptly and reasonably possible, you avoid compromise to integrity and professional independence, and you comply, as is your expectation, with the rules. Now, breach of the rules is not per se professional misconduct or unprofessional conduct, but it is evidence of that, linked to all the circumstances of what the breach is and the magnitude of the breach. So there are sanctions if you do breach the rules. And the other thing, Rule 5 there, which will appear again as we're looking through the answers to these questions, is a solicitor should not engage in conduct which demonstrates that he's not a fit and proper person to practice law, which would suggest that he or she is doing something that is prejudicial to diminish the public confidence in the administration of justice or would bring the profession into disrepute. It was a very wide umbrella there, and of course regulatory bodies, law societies and the legal practitioner conduct boards and the legal services commissioners, who are the regulatory agencies in the states that police and enforce the rules and deal with complaints about practitioners, have that as a fallback position when looking at any allegation against a solicitor for breach of any of these rules or behavioural issues generally. All right, so let's go to the exercises. These things occur quite regularly in practice, particularly with the litigators, because court litigation of its nature is adversarial, as we know, and is a lot of time posturing in a position to strengthen your position against somebody else, and that can lead to a position or circumstances where you might want to be more bold or assertive or robust in articulating a legal position or your client's position than you might otherwise do in a non-litigious state. And those of us in litigation would know certain practitioners, certainly in this state, who renowned for being particularly assertive and bold in the conduct of their litigation. And we, in litigation, are more alert to them as to who those people are, and that it's not unusual to experience that. The first one, if you accidentally disclose your client's confidential information or privileged documents, what is your position? Well, the overarching principle, other than the 2-3 rules I've mentioned, the most fundamental duty to the client is to protect confidential information. And a lot of the other rules rivulet from that, or are examples of that in a different guise. Right? And that will appear to evidence itself as we work through these exercises. If you do disclose your client's confidential information or privileged documents, then obviously you need to tell the client it's happened because you have an obligation to protect their confidence. So it should be something you inform them. And then, of course, you can inform them about steps you're taking to recover or preserve that confidence as legally you are able to. If the other party has got this confidential information, obviously you quickly inform them that it was given in error and you recall it. You ask for it to be returned. You ask them to destroy any copies of it. If it's in litigation and it becomes an issue where you may or may not have trust or confidence in your other practitioner on their word on that, you may ask them to do an affidavit to that effect, particularly if the client may have had previous dealings in an adverse situation with that particular practitioner, and the client may have mistrust of that practitioner if you don't, and it may be that they would feel more confident or secure about it with an affidavit, then that should be requested as well. If it's a privileged document that's been mistakenly listed in say, a list of documents, or two scenarios there can come into play. If before inspection of that list of documents, you are alert to the fact that it's wrongly there, then you can recall it, take it back, redraw the list and remove it. And generally speaking, in my experience of these situations, over the last 5 or 6 years in particular, not that it occurs that regularly, but where it has, other practitioners are pretty accommodating in that respect, because I think the general attitude is we all know what the rules say is our expectation to be cooperative and do the right thing here, but it's also therefore, by the grace of God, go I, and I would like to think that if it happened to me in the same thing, that the practitioner would do the right thing and allow me to amend without any problem the document and to take the privileged document off the list. There are some rules that do contour the obligations in this respect, and if you look at Rule 30.1 in the rules, and also Rule 30, you will see there that they deal with this sort of scenario. Rule 30.1, which says that you're not supposed to take advantage of another solicitor or a client, and indeed Rule 31, which talks about the legal obligations in the event of an inadvertent disclosure, how you're able to request the return of the document, its destruction, and if you need to, you can ultimately go to the court for orders to this effect, but I don't know of a situation where that's ever become necessary, because you refer them to the rule. Most solicitors know this anyway, but if you refer them to the rule, if anyone is doubtful about it, they'll usually be most accommodating on it. Okay? So there is also a provision in the Evidence Act that broadly captures this scenario, and that's Section 122 of the New South Wales Evidence Act. A client may lose its right to client legal privilege where they have knowingly and voluntarily disclosed the substance of the evidence. The operative words there are knowingly and voluntarily disclosed. And obviously the general position that prevails is if you inadvertently or mistakenly did it, then you haven't knowingly done it. Therefore, you aren't saying that you've lost your ability to claim privilege on the documents, and you haven't waived your privilege. So that dovetails neatly with the professional conduct rules. Okay? If we go to the number 2, what's the response to receipt of inadvertently produced privileged materials where you get them, and the other solicitor may not yet be aware that you've got them or that they've arrived at your office in error? Obviously if they're alert to it quickly and they get in touch with you, well, there's a certain process to be followed. But what if you get them and you don't get any immediate or short-term contact? What's your position? Same sort of principles apply under Rules 30 and 30.1. Don't take unfair advantage of another solicitor's obvious error, and also be conscious of the duties and obligations about the inadvertent disclosure of documents and what the expectations are. So you, if you are true to your code, would contact the solicitor and say, look, I'm just checking with you whether this was really intended to come my way. Say if you've read it or you haven't read it, just say, look, I started to read it, I got to page 2 or 3 and I realised this is probably something I ought not to have. Be truthful. Or if you've read the lot, then say I've read the lot. Honesty is the best policy. Generally, though, you know pretty early in the piece whether you ought or ought not to have that particular thing. But about page 1, 2 or 3 would signal a warning sign. So be upfront about it and then say to them, look, I think if you tell me, yes, it's okay, well, then I'll continue with it and I'll keep it. If you say, no, look, it was sent in error, thanks for alerting me, well, let's follow through the process of my destroying it and my returning any copies that I have. And therein we'll just work together going forward. There is a danger that you could be restrained, depending on how much you've read of it and how much knowledge you can be imputed to have retained from it. There's a danger that you may be requested no longer to act, or a court may actually order you no longer to act. I don't know of any cases where that's happened with solicitors. I do have cases where it has happened with counsel. And that's because sometimes the solicitors have sent it on to counsel and asked counsel to digest it all and tell them what they should or shouldn't do with it. Because the counsel then has gone through the whole of the material and got a lot of knowledge about it, even by agreeing to return it or destroy it, that imputed knowledge or that retained knowledge is a danger, particularly in the conduct of a case in a litigious matter. And there have been examples where they can be asked to either disqualify themselves, or a court will order they no longer act in the case because of that. So there is that risk exposure. Okay. I've had the question there, should you look at the documents? Well, simply no. If you think that they're not something you should have, then do the right thing. As I say, generally take the position of do therefore for the grace of God go I, or do unto others as you would have done to you, right? What you would expect to have occurred in that situation. I've raised the point there in the question, what are the consequences if you read the document that's come to you inadvertently? Well, as I'm saying, you've got to balance your duty to the client to run their case the best they are, or to protect their legal position the best ways they are, vis-a-vis your duty to the court. But remember, in that situation where there seems to be a conflict in that, the duty to the court under Rule 3 is paramount, because the courts are there to ensure the proper administration of justice. You're an officer of that court. That ultimately, that's the paramount duty. So even though it would subjugate your duty to the client to best assist and guide them and give legal advice and advance their interests, particularly in a litigious matter, you can't do that at the expense of breaching your duty to the court and the proper administration of justice. And nor can you argue that there's any waiver of privilege on that, where it is inadvertent or mistaken. And the Evidence Act itself will come into play there and assist anyone saying you can't use that for any purposes. Okay? Yes?
This is probably a silly question, but just in the context of inadvertently disclosing confidential information, where does the insurer come into it? Do you...
Well, if you think that there's a potential...
Yeah, so before
if you think there's a potential claim...
Sort of looking at making a notification and speaking to the insurer, or...
No, not if it's been inadvertent at your end and you're telling the other side that it's happened, make sure you give them back, make sure you destroy them. I remember, Anne, this happened last year with something that you got, and I think you'd sent it to me. accidentally, because it was part of something we were doing jointly, and then they got in touch with you and said this was accidentally sent. We need to be sure that it's gone, it goes back and it's destroyed. And I remember you then followed me up and said, look, I think I sent this to you too. And that can happen in the way that various matters are being dealt with by different people. And you're at pains to make sure that I got rid of my copy as well, which is what you would do, of course. And of course, you just delete it and you confirm its deletion, So there's no issue then about, and there's no potential claim or risk of claim, so you wouldn't need to notify. If you had resistance on the other side, then you would just notify circumstances with the potential to give rise to a possible claim. It would be at the lower end, but you would just inform the insurer to that effect, right? And the main issues that flow from that are usually the costs to the client of getting fresh lawyers if you're taken out of the case. Now, that could become quite monstrous if this occurs like 2 or 3 years into a larger litigation matter, and then you're taken out because of that, because the cost exposure to a client to get a new set of lawyers in and up to speed with 3 years' work could be quite horrendous, And that's where the client would say, well, this is not my fault, this is because of what you did. It's going to cost me $300,000 to rebrief on this. What amount are you putting in? I think you should put in a lot, right? What do you think? Then it clearly is an insurable question, right? And the insurers would hopefully indemnify you in that situation, right? It'll depend on all the facts and circumstances and your policy, but generally in that situation you would get an indemnity. But that's where it would come out to play, that notification would become important. Right? But it's a question of, like all these things, you make the assessment. I mean, I do that probably, if not every day, every alternate day here with a national firm of so many practitioners where you get questions rise about various things. Is this a situation where we should notify or do something with our insurers? A lot of times it's not, because it's not that advanced or it's not that risky at that point in time. So you make a judgment call. Other times it clearly is, in which case you do. So it depends on the facts. Okay. Number 3 there, what if you accidentally misrepresent your client's position or the legal position to the court? Well, once again here, the Rule 3, your paramount duty to the court and proper administration of justice here will dictate to you that you have an obligation to correct that position. It's clear. And even though that might potentially be adverse to your client's position, once again, because of Rule 3 and its clear statement of the paramount duty to the court and the proper administration of justice, then it overtakes everything else. So you need to correct that position.
Malcolm?
Yep.
Do you think your opponent has misrepresented the position? Presumably you ask them to... Ask them to correct, and if they say no, would you be then obliged to bring that to the court's attention?
If you think they have, as a factual matter or as a legal issue?
I'll assume maybe they've...
It's easier for a legal issue because you make submissions on what the law is.
Exactly, and they've missed something.
As a factual matter, well, you can. There's no question that you can't, but you've got to be wary about making unfounded allegations against another, because there's another rule that says that against another practitioner. And once again, it's a do unto others as you would have done to you. I mean, you may not like the way they run their case, and you mightn't like their client, you mightn't like how they're doing things. But if it's a clear false statement, and they may, obviously it's made easier if they even admit that it's false to you. Well, then clearly your duty to the court, so will you say, well, I've raised this, I've asked them to retract it, I've asked them to fix it, and they haven't, right? Therefore, I'm informing the court in that situation where, provided it's not your client, because you can't breach your duty of confidence to your client, well, that's a different scenario again. That'll come up later in one of the exercises. Okay?
Yeah, and what happens where your knowledge of the falsity arises through without prejudice communications? Can you still bring it to the court's attention?
Well, without prejudice creates a bit of a dilemma for you. you've got to be respectful of them without prejudice communication. Not known, and I don't know of any reported cases where that's ever been before the courts. Right? If it has, it's not widely occurring. But you wouldn't go against the nature of without prejudice communication, because once again, you've got to be conscious of that rule that says you won't take unfair advantage of another solicitor, and if they've said something without prejudice communication, then that's clearly what they have done. So you've got to balance that obligation under the rule with the duty. Ultimately, though, the duty of the proper administration of justice will be superior, but you need to proceed a bit more cautiously in that situation. And certainly you would go through the steps of encouraging them to realise the error and encouraging them to volunteer the correction. Okay? It becomes different when you have problems with your own client. We'll deal with that in an exercise coming up, all right? How you deal with that one. All right. If we go then to the next question there, what can we do where a client expects you to go to a court and run a case that you think lacks legal foundation? And that, I guess, for a lot of the people in the room, if you're in-house counsel, that may come about in a day-to-day or week-to-week activity where your board or your management say to you, I want this done this way, and I want you to make sure it happens this way, and you may have a reticence in that respect about the value of doing things the way that, you know, in effect your superiors or your management tell you to do it. The general proposition that you start from is that every client has a right to have their legal position explained and pressed. And so long as it's not being pressed in an unlawful, unethical way, the merits of it aren't really relevant, right? Excepting you're not allowed to press falsehoods, right? Or things that are plainly wrong or false. So that you've got to balance what your client is telling you they want to have happen, or your management are telling you what they want to have happen, with your duty to the court under Rule 3. And also there's another rule, Rule 20, or Rule 19 actually, Rule 19 of the rules. If we go to that, it talks about frankness in court, or frankness in dealings with the court. You must not deceive or knowingly or recklessly mislead the court. Well, that gets into the nature of if what you're being asked to do is false or misleading, right? But if the client says, I want this case run this way, or I want you to do it that way, or I want you to ensure that you raise these issues, provided that there's nothing illegal or false or misleading about you doing that, then you still have an obligation to follow instructions.
Where does the certification of proceedings come into play there?
So that.
Where does the certification of proceedings come into play there?
Well, obviously when you're doing your pleadings, remember you sometimes certify at the bottom that you believe that it has reasonable prospects, etc., etc. Well, and obviously in the federal court and the state Supreme Court rules, you will have that certificate come in. Well, that's the judgment call you have to make, right? And in doing that, if you feel that it generally doesn't have any prospects, and there is the other rule that you're not to misuse the court processes, and that's Rule 21. Your responsible use of court processes. You must ensure that to invoke the coercive powers of the court, which includes all litigation, is reasonably justified by the material then available to the solicitor. So that rule dovetails with the certification. Once again, if you actually think that this is a hopeless case, it will be vexatious to continue or to do it that way, then you have an obligation to tell the client that, you know, you that's your assessment. You ought to do the right thing and say, well, I won't act for you. That, you've got to be careful about the duty not to disclose their confidence to the court, which is the other thing you're trying to balance. So the best thing is to just withdraw and let someone else deal with the problem. They might go to another solicitor and they'll do it that way. You know, some people with lesser ethical positions than you may have, but that's their dilemma. Huh? But in our case, we would say the certificate requires us to make a proper evaluation of prospects, and we've got to be true to our oath. Remember, we're officers of the court. In signing that, the court's going to rely on that, right? That proper assessment has been made. And you've got your own position to be mindful of your duties to remember number 3, to be paramount duty to the court. Marked with number 4, you're not to compromise your integrity. Yeah? So they're the two that come into play. Okay. So remember there. Rule 19 about the frankness in dealing with the court's duty, coupled with Rule 21, particularly Rule 21.3, and that you are responsible to only use the court's processes. Well, there you go. It's a test, so we can ignore it. Okay, that's good. So just be a little bit wary of that. The question of case management versus litigation strategy. I think that's it. Okay. Here we get guidance from the High Court's judgments in Aon and the ANU. That's largely the Bible on this nowadays. You know, if your pleadings are in and advanced, you ought not to be dragging the chain, firstly, on finalising them, or else they'll give you the whip hand about, you know, the proper administration of justice having not necessarily speed, but due and proper process and a reasonable time period to get things done being operative. And if in the course of doing that you felt some obligation to do things earlier, then you really were in a proper position to do so, and then you later realise that you haven't properly pleaded a matter, then you don't have an automatically right necessarily to replead or amend your pleadings. Certainly in Queensland you do at certain stages up to the litigation, but other times you'll need either the agreement of the other side or the court to do that. But you will be able to, even under the Aon principle, seek the leave of the court to do an amendment if there's a genuine basis for doing it. Because the general principle here at work is, remember, the proper administration of justice should operate in a way that a client should not be severely disadvantaged because of a wrongly pleaded case or subsequently realised circumstances or facts or legal issues that would justify the need to amend. And there's a balancing exercise there. So you would look at the reason for the delay in getting it right. You're balancing that against what prejudice would happen to the opposing party, what prejudice would happen to other people in the litigation, particularly if it's a pipeline litigation and you're the first in several ones that are going to be affected, the costs involved in doing the amendment at that stage, and the need for obviously the other side or other parties to then have to respond to the amendment. Public interest dictates into proper administration of justice and public confidence in the system, etc., etc. So you're not barred from doing it, but the Aon principle at work and the court's expectation of proper administration of justice in a due process way would say, well, you better have good reason to be coming to us at this stage wanting to do your amendments or wanting to change your pleadings. So that's pretty self-evident. Number 4 there, can you record conversations? The general principle here is you can't knowingly use listening devices to record private conversations unless you've got the express or implied consent of the person who you're recording. And you'll get this every day, of course, when you ring up, whether it's Telstra or if you ever get through to anyone. Or the best examples nowadays are the electricity people. You can never get anyone to talk to anyone about electricity, because they get so many, obviously, horrendous bad complaints. They don't want to talk to anyone. But in that situation, Section 11, it is, of the Surveillance Devices Act in New South Wales, you can't record a private conversation without consent. And married with that is Section 7 of the Federal Commonwealth Telecommunications Interception and Access Act. And also dovetailing that as a question of evidence, being able to use that in any evidence is Section 138 of the Evidence Act, which says, you can't use in any evidence, as evidence in any proceedings, evidence gathered in a way where it is unlawfully obtained or it's undesirable, I think is the wording of the statute, to allow that evidence to be admitted in those circumstances. So you're going to be sort of outflanked on all three there. You've got the State Surveillance Devices Act legislation, you've got the Commonwealth Telecommunications legislation, and then you've got your Evidence Act that's going to get you, even if you somehow think you can get past those two, by arguing implicit consent. Remember, because it does say implied consent in the circumstances, but if you do get through those, there's always the one you have the argument, well, it's still undesirable that in this situation it not be able to be used. So you've got all those risks at work. And it may be the duty to preserve confidential information under the Rule 9 is also at work there, in that if you were to use that, you would be misusing confidential information, so you're going to get outflanked on that one as well. So you've got that at work with the other legislative prescriptions. Okay.
Can I ask a question about
yes? Yeah.
I know that some states have laws that aren't as strong as New South Wales laws say. So if you were in another jurisdiction and the client...
Like Queensland in particular, because it has occurred recently up there, yes.
Yeah, and I think in South Australia as well. And so if a client, say, takes a meeting that they had in Human Resources and then they were coming to you for some point of litigation, what would be the best way to deal with that material?
Well, remember the Evidence Act, it's pretty much uniform, the Evidence Acts in the states now. So that 138, it certainly exists in Victoria the same way. I think in Queensland, so you're always going to get that one at work, even if you don't have the state. You've got the Commonwealth Telecommunications Act, which is going to be a problem for you, no matter what the state is. You may not have the particular surveillance or taping of conversations one, which New South Wales and Victoria definitely have. Queensland doesn't. But you've got the Commonwealth one at work. You've got the Section 138 Evidence Act at work saying, well, this shouldn't be used because it's undesirable in all the circumstances. So, and you've also got the duty not to take advantage of another solicitor. If it was the solicitor that you were taping, and there may have been something said, and you've also got the duty of preserving confidential information under Rule 9. So you've got a few of them all at work. And then, of course, if everything else fails, you would just argue the old Rule 3, that the proper administration of justice and the duty to court and dictates that this not be able to be used. That's what happened in a litigious sense. Okay. See, the fact that you don't necessarily have that legislation in some states, Queensland doesn't. I know there was a real fracas last year about something up there where something was taped. But you've got the other ways of dealing with it anyway. Okay. Number 5 there, are there any ethical considerations in getting published? Now, this is an interesting one. There's a rule here now, Rule 28.1. If you look at that, solicitors ought not to make public comment about matters before the court. And this was brought in as a result of a couple of cases in West Australia where solicitors and counsel are in the habit of giving doorstop commentaries to the awaiting media about the way their cases were being run. Right? I think one of them involved a politician and some allegations of corruption. And the general principle here is, for matters before the court, there are court reporters who can go and report on what the material is in court. They're accredited for that purposes, and they are obviously bound by certain principles of their journalist code in doing it that way. But you as a solicitor or counsel ought not to be making public comment on the proceedings in a court. Okay? It's different if you're making a public comment on the outcome rather than the actual proceedings. And indeed, I remember I did this ad infinitum some years ago where, I did a case, the famous lotteries case, where the little old man who was in his 80s, who won the lottery, was denied his payment because of a technical issue from the lotteries commission where they cancelled his winning ticket. It was very much akin to Donoghue and Stevenson, in the 2000s. This was, the little old lady who drank the stale and ginger ale and how the courts were well disposed to her. And this was the little old man who'd been putting his ticket in for 45 years, the same numbers, and suddenly when he put it in error, his ticket was cancelled. And he said, but I've got the winning ticket. Yeah, but you got a ticket, but it's a cancelled ticket. In that we did win that one, and there was an awful lot of public interest in that, mainly because it was, the David and Goliath position of the little old man with the winning ticket. And everyone related to that. Well, what if that were me, right? And I did do a lot of interviews outside the court and then subsequently with news and radio, TV, about the outcome. But that wasn't about the cases that was ongoing. So there is the difference. And that's basically making fair comment too on the case. And that in particular was one where there was an awful lot of public interest, right, generated, particularly because of the aggressive way that the Lotteries Commission were saying, well, they can do whatever they like under their rules, including cancelling your winning ticket. Right? And there's nothing you could do about it. Well, we said, as that case proved, well, there is. Okay. Number 6 there, can you assist clients in unethical and unlawful activities? Well, your basic principle is under Rule 8, if you look at the rules there, you have an obligation to follow your client's instructions, but they must be lawful instructions, right? Lawful, proper and competent instructions is the wording. Now, obviously, if it's unlawful, then you cannot follow it, right? If it involves you committing a breach of these rules and acting in an unethical way, once again, then you're entitled to not follow it. You must tell your client that this would be a breach of the law or be a breach of my ethical duties, including the paramount one of duties to the court, and therefore I cannot do it. And if you insist on me doing it, well, I will have to resign from acting from you. And so that's where it is. Okay?
Malcolm, sorry, in Rule 8, that reference to competent instruction, is that a client who's legally capable of... Is that what that means?
Yes and no. It's broader than that. It means that it's in a situation where you are able to assess them as being relevant to the case. Huh? Okay. It's not the you're thinking of capacity, are you?
I just was curious as to the use of the word competent.
Yeah.
Is that taking them for the right person, like you, a director of a company, as opposed to?
Oh no, I wouldn't say that. Well, you're doing what I'm saying. You're looking at capacity issues, and then that goes to the infant versus the adult, and then you get the variable of that. The infirm aged person, or then in the worst case scenario, you get the potentially insane person, which will all go to issues of capacity. Right? Okay. The one thing to be mindful of there, which also does impact on this, is Rule 20 about the delinquent or guilty client. That is, if you become aware in the course of proceedings that your client has given you false evidence, maybe it's in terms of witness evidence in a case or in an affidavit, then your obligation is to tell the client that you have a duty to the court to ensure the proper administration of justice. The client must agree to recant that and to put in a truthful position, or if they won't, that they will authorise you to do it. You know, if they're frightened themselves or embarrassed or apprehensive in any one of those situations of themselves going to the court and correcting it, then authorise you to do it. Because that is the important thing to do. And if they won't, well, then your duty is to retire or resign from acting from them. Now, you can't obviously disclose to the court or the other side why you're doing that, because that would involve a breach of confidence, you know, but courts aren't silly, judges aren't silly, and other lawyers aren't silly. There's got to be a reason why you're suddenly extricating yourself, right? And if they are wary of what's being said or have reason to be suspicious about that evidence, then they'll join the dots, okay? But that's the Rule 20 rule. Number 7, how do you deal with unrepresented persons? Well, basically, you get guidance from Rule 34 here. It's you have a duty to be fair in the dealing with others. Now that's a broad concept. That will be interpreted as having regard to A, whether they're legally qualified or not legally qualified, and how you ought to be more accommodative of them if they're less legally qualified, or sorry, not legally qualified as against being legally qualified. And if it's quite obvious from the way that they're conducting themselves that they're and not terribly well educated or not terribly well versed in the English language, again, that will dictate of how the expectation is that you deal with them. So be wary of that one. And of course, those of us in litigation who have dealt with the unrepresented clients know the way the courts will very much try to be accommodative of people in that situation to allow the unrepresented litigant to have a fair go. But even judges at times will get frustrated by the way some of the things they do and say will occur, and will start drawing lines in the sand. But it's got to be a little bit of elasticity there in the way you conduct yourself with them as well. Okay? Number 8 there, can you deal with clients of other practitioners? Well, Rule 33 here is a restatement of the principles that's always been at work. Basically, you cannot deal with another solicitor's client at all. You have a duty to respect the other solicitor who's acting in the matter, to deal with their client. Where it will happen in day-to-day is sometimes that person will contact you without the other solicitor's knowledge and say, well, you know, I'm sick of my lawyer, all he's doing is running up fees for me, I want to deal with you. You need to say, well, look, thanks for your call, but I can't deal with you while you've got another lawyer. You need to go through that lawyer, tell him or she to get in contact with me, and I will deal with them. And your best bet to do in that situation is then ring the other lawyer or email them and say to them, look, your client's made contact with me. I've praised them with the position that I can't deal with them, and I've referred them back to you. Now, the reason that becomes important that you do that follow-up call or email is if later they will allege that you have told them things or misled them to certain positions, the fact that you've made quick contact with the other solicitor or appraised them of the contact and how you have redirected them will shore up the position of your integrity in not having dealt with them. And that's the very reason you don't do that, because there is a great risk that you will take advantage of them, either consciously or unconsciously. And that's why the rule is there. Yep.
How do you navigate that in an employment context?
Say that again?
In an employment context where the client or the other side's client is your employee and you might have day-to-day operational matters to deal with, but
well, as long as you don't deal with the matter that's the subject of a dispute or litigation or communications, you deal with them on anything else. There's no problem there. But if they want to talk to you about that matter, well, if they are legally represented, you say the same thing. I can't deal with you on that. You've got a lawyer. I've got to deal with the lawyer. You should vehicle it through them. Yes, it wouldn't matter. But that's not to say you can't deal with them on other things. particularly day-to-day operational matters and conduct of your business, as long as you don't talk about that particular issue.
It can be blurred sometimes.
Or if they raise it, you just appraise them. Look, because you've got your own legal people and we've got our legal people, it's the legal people who deal with these things. Now, it's different if they sack their lawyer completely and they don't have any legal people. That's quite different. But it's in the case where they have lawyers, you've got to be respectful of that. Okay? Number 9 now. What happens if your client lies in the witness box? Well, I've just referred to that before. You know, the rule that says that you have an obligation to get it corrected, the evidence to be corrected. You tell the client to do that, or give them the alternative, or if they don't want to do it, or, as I say, apprehensive or uncertain or questionable about doing it, say, well, authorise me to do it, and I will do it. Right? But you need to say that, you know, I have this duty, paramount duty to the court, the proper administration of justice. Now that I've become aware of this, I have to tell you it needs to be corrected. Now, either you do it or I do it, or I no longer act. I mean, that's the 3 scenarios. So you pick. You do it, I do it, or I withdraw. That's where you get to. Okay. Number 10 there. Can you represent 2 defendants at the same time? In theory, yes, you can. But the problem is always where there is a potential conflict of duty and interest, or duty and duty, because if their evidence is going to be potentially at conflict, then you're going to be in a terrible ethical dilemma where your duties to each are not consistent. Because remember, your duty to promote the particular client's interest is in a way where you can't do that at the expense of your other duty to that client. So if you're going to do that, then you say, I can act for you both, subject to you understanding that if a point is reached where I make the judgment that I can no longer act for you, then one of you has to go, and let's pre-agree on who that's going to be, and let's be fully understanding that the cost of you going to another one is something that person is going to have to pick up. Now, whether that's something you two share, that's up to you, but don't look to me. Right? Okay. So it's got to be one of those fully informed consent scenarios where you do act for them and you explain the risks of acting for them, and you also make it clear that I can only do it so long as there's a position that's reached where so long as there's no position reached where I see there is a conflict or there is a possible conflict. Because at that point my duties to both of you dictate that I can't act for you both, and my duty to the court, right, and that's, we always come back to that one too, hide behind that one if you want to, dictates that I've got a responsibility for proper administration of justice to ensure that these dilemmas don't occur. Okay? Yes?
Did you also get the problem where you have, if you're acting in that situation with joint action, then you find a conflict, but you aren't able to actually disclose what the conflict is to the other party?
Oh, yeah.
So
It's your call, remember. You're saying to them, I'd make it, and if you've done it right at the beginning, you've said, if I make the judgment down the track that there is a conflict or a potential conflict, and I then say to you, I can't act, then I can't act. And then we pre-agree on what's going to happen.
you might never know what the conflict is. No.
They might never know.
Yeah,
No, exactly. That's actually good. That's actually good, because no one's advantaged then in that situation. Right? Because you don't tell them.
Yeah, but the client can't understand then why.
Well, they don't need to, because if you've told them properly, you just said, when I make that assessment, and I can't, you can even go and say, and if, when I make that assessment, it may well be that I can't tell you what it is. And it may, in some cases, it would be unethical for you to tell them.
And would you be telling the party that you're still acting for why that is then, so they will know and the other client won't?
No, because that would involve you breaching your duty to your former client, who's the one you've turned away. So you couldn't do that. Right? Because remember, you still got duties to the former client as well as the existing one. And you explain it that way. So, and if they press and ask you, say, look, I really can't tell you, because that would involve being breach of the duty to that person.
Malcolm, you may have to say, even if you pre-agree what will happen in that event, that there may be a circumstance where you have to cease acting for both of them.
Oh, yes, definitely.
But the scenario you're talking about, you may have information that you can't continue to act without disclosing it to your client.
That's right. That's right. In that situation, yeah. Well, that's once again your call.
Yeah.
As I say, there is a rule now that says you can continue to act. It's Rule 11.5, where you get the fully informed consent, right, of the clients. Now, that's a bit of a problem one, right? My dilemma of that is, what is a fully informed consent? And that must be, you've got to explain to them that one of them's going to go, it's pre-agreed who's going to go, and it's pre-agreed that the cost of them going elsewhere is their problem or will be shared by both. But most importantly, from your point of view, it's not on my tab, right? That's really important. And that'll be the one that causes the most concern, because it'll be the cost factor that will irritate and ignite problems, okay? All right, so note there, Rule 11, particularly 2, 3, 4 and 5, they're about the conflicts of duty and interest. Just quickly, just to marshal through the rest. Number 11, what should you do when an allegation is made against another person in the firm? And what's the partner? Well, I've had to deal with these. You do what you are expected to do. Remember, there's the duty of integrity of professional practitioners, and there's a proper administration of justice matter. There's also the Rule 5 that a solicitor should not engage in disreputable conduct, and that will be, a fact-finding exercise in all the circumstances, and you may need to be guided on that in reaching a decision on that, and that will dictate whether that person can continue to act in the matter. That will usually resolve it, right? And then people will move on. But if it doesn't, particularly if clients will dictate that, or other members of your firm dictate their unhappiness with it, well, then you'll have to deal with that in a commercial as well as a legal way of what's the appropriate path. But if there is an allegation, then it could raise questions of breach of Rule 5, right? Disreputable conduct, improper behaviour. That's where you would focus your attention, and that's the reason you would say, well, we have to look into this. Or if it's more clear-cut that you have been guilty of a conflict of duty and interest in whatever it is you've done, well, that means you can apply that rule. Or a conflict of duty and duty, or duty between former clients as well as existing clients, all those things come into play. But the one that will rivulet with them, in concert with them, is the Rule 5, the duty not to be involved in disreputable conduct or things that would bring the profession into disrepute. Okay. Number 12, what are our duties to the client in respect of our legal charges? Two things here. The Uniform Law and the Legal Profession Acts of the other states require you to give letters of engagement, which you make a lot of disclosures, including what the range of your costs will be, your hourly rate, what an exact cost estimate is in New South Wales and Victoria. And you can revise it as you go on. You've got to advise clients of their rights to call for monthly updates or bi-monthly updates or fortnightly updates on their charges. You've got to tell them they have rights to have them reviewed, and that's all set out in your letters of engagement, that they have rights to have them assessed. That will always be set out in the letter of engagement. But the other thing that's at work here is the Rule 12, of course, that you can't have a conflict of duty and interest, and there's, at the beginning of that rule, I think it's 12.1, it says that you can only charge clients fair and reasonable fees, that you can't induce into the client. It's like the old undue influence principle in equity. You can't take advantage of them because of your solicitor-client relationship to charge them horrendous fees. Like if you charge them like $85,000 for doing a simple conveyance, even though you know that they've got like $80 million at the bank, that is not fair and reasonable. If the normal charge of something like that would be somewhere between 800 and 2,000, depending on the circumstances. Right? So that's the rule that comes into play. All right, fair and reasonable fees. And conflict of duty and interest principle at work there. Okay, plus of course the regime under the Legal Profession Acts, which dictate what your disclosures are to your clients and what their rights are. Now I think there's one last one. What about third-party payers in that respect? Well, if there's a third-party pay, you have an obligation to make the disclosures to them too, because they're the ones who are going to be paying the bills. And that may be a trustee in a trustee beneficiary situation, or it may be a parent guardian for a child or infant situation, or it may be relatives or associated companies giving assistance to other companies in getting legal advice and providing financial assistance. Last one, number 13 there. What should I do if a client requires me to change my legal advice? I've only ever had that happen once in my life. And I just said, well, I wouldn't do it. But I did at least go through the exercise of thinking about it. And I think you owe your client that duty, that if they say, can you relook at this, can you reformulate this, can you come down another way on this, well, I think you owe it to them to go through that process. And after all, they're paying for you to go through that process, as long as, once again, you're not taking advantage of them in doing it. But if you come down to the same position, no, there's nothing wrong with what I've said, or I still stand by that, then your duty is to remember, number 3, paramount duty to the court and a proper administration of justice. And if we get back to the position you make the assessment that this case has no merit whatsoever, or would only succeed by relying on false or misleading evidence, and I have duties not to do that, and therefore I advise you it can't happen, and I certainly can't sign the relevant certificate in the litigation process that I have assessed this as proper legal prospects, then there's no point in us going forward. One last thing. There's a rule which talks about dealing with a person who's covered by insurance. If you know that someone, and it may be that an individual comes to you and you know they're insured about a particular matter, you shouldn't deal with the individual without at the same time dealing with their insurer or without their insurer's knowledge. Because the drama here is, of course, is they may make admissions or may say things that will compromise the insurer's position. And you're not to take advantage of that. Okay? So just be wary of that one if you know that they have insurance. And that may be they've said that, or it may be an insurer has contacted you to alert you to it, and that means that you shouldn't deal with the individual without the agreement of the insurer, or without the insurer being involved at the same time. That's another one. Okay, but generally, as I say, the main one is number 3, the duty of the court now paramount, administration of justice. And the other one, don't compromise your integrity, don't do anything that would cause the profession to come into disrepute. And the old, biblical principles of do unto others as you would have done to you, it really helped fashion you. And that one particularly I use when I might be writing a quite vituperative letter to another solicitor. And I might say, well, if I got that letter, what would I feel? And if you say, well, I wouldn't really be happy about it, I wouldn't like it, well, then go back and revise it, right? Pause before pushing send, right? So that's sort of the principle at work there. And that one, of course, includes be respectful in correspondence with other practitioners. And I know at times we can pull our hair out with some of them. And we can think, how can they be in this position, or how can they be running this case, or how are they giving that sort of advice? But you've got a balancing exercise there with your duties. All right, now, we're due to stop, but I will take any question if anyone has a question, because I think we're going to have a coffee and tea break anyway. Has anyone got any questions yet?
In defending public liability matters, where plaintiffs often go to lawyers that charge on a no-win, no-fee basis, and they think there's no downside, is there any issue with reminding them that if they lose, which we say they are almost certain to do, that we'll be seeking a cost order against them, and we know that they've got a house, and we, if necessary,
that's one of the disclosures. That is one of the disclosures you have to make under the legal version of law in your letter of engagement. That if you are involved in
the other side, telling the side. So at a conference, reminding the other side's client through their lawyer that it's really not a case of no downside for your client. if they lose, then we'll seek a cost order against them.
No, that's right, okay.
And
They can press themselves their lawyer, yeah.
and make them bankrupt if needed.
That's right. You can do that. Their lawyer's there. You can say what you like, but their lawyer's there. Now, he or she mightn't like it. I even did this a couple of years ago myself in a situation where I was at a settlement conference. It's notorious here. I didn't want the settlement conference because I thought it'd be a waste of time. And we went to it, in the spirit of trying to get things resolved. And I said, well, I hope you know that, let's be clear here from the start. There's no way we're paying you anything. So don't be looking for anything. The best way for you going forward is you agree to pay us $100,000 towards our existing $170,000 legal fees. And that's the best deal you'll ever get. Well, then at the end of the day, after all the toing and froing and then changing their offers of settlement 4 times, from an initial $250,000 we paid them to $100,000 we paid them, the message still hadn't gotten through, right? We did eventually go through to run this trial, which we won comprehensively, and the other side is now exposed to all our costs on that, which are about $380,000. Right? And as I said, this is the best deal you'll ever get. Right? That was a week out from trial, or a month out from trial actually. But there's no harm in saying that. So the client is knowing what the risks are. But once again, you're protected because the other person's lawyer is there. But you can't do it away from their lawyer. Let's have a settlement conference, and I think you said that's where it was at. And there's no problem. You can say what you like to get the message through. Well, I tried to get the message through there unsuccessfully. But you do. And you're doing as much for your own client as you is, because even when you win, and even in there where we have indemnity costs, once of course you go through the taxation process, you'll never get 100%. You may get 90%, but you're still 10%. Well, even on that situation where I think the fees are totaling $385 and we'll get 90%, well, the client's still going to be down $30,000 or $35,000. So this, but at least you've made it clear along the way. Okay, any other question? Okay. Well, as I say, if you have any queries about anything I've said today or other scenarios that may be ignited in your mind, then feel free to email me. As I said, I've left my cards there if anyone wants to get a card on the way out, so you've got the records. I hope you found it informative. Rather than go through the rules ad lib, I thought this is an exercise that interstate people have used previously by doing these exercises, and it helps focus the mind on these particular scenarios. And they're ones that do happen, not regularly, but certainly they're not unusual or irregular either. Okay then, thank you for that.